Hello, everybody, and welcome to Macro Pro and Friends webinar edition. Earlier this week, I talked about the gnomes in Iceland and how in Iceland they have 12 gnomes for Christmas. And I mentioned the mischievous one ended up in my luggage. Well, he showed up this morning. We're sorry we're a little bit late, but we have a great program for you. We're so lucky to have Jim and Hilary with us. They're a husband and wife dynamic duo that practices law. Hi, Jim. Hi, Hilary. How are you?
Good morning.
Good morning.
How are you?
Good. Great, thank you very much. I'm going to do a little bit of quick housekeeping, and basically it's going to go just quick, so we can start with our presentation. This webinar is worth 1 CEU. You must be logged on to the GoToWebinar platform in order for them to record your time and attendance. If you just phone in, unfortunately, you will not receive a certificate. For those of you who are logged on, you will receive your certificate within 1 hour. If you have questions for Jim and Hilary, you may put it in the question box, and I will be happy to ask those questions to them at the end of the program if there's enough time. If there isn't enough time, I will go ahead and send them those questions so that they can respond to you directly. The handouts that they have today are attached to this webinar, so please make sure you download them so you have not only their contact information, but all the information for future use. There will be a replay of this and all Macro Pro webinars on the Macro Pro YouTube channel. So with that, I'm going to go ahead and let's get started. Jim and Hilary, the presentation.
Yes, good morning, everybody. Obviously, I'm Hilary and that's Jim. We're from McLaughlin Coffinberry. We obviously do defense of insurance companies for the workers' compensation. We do also 132As and S&W claims. We appreciate Diane. Thank you very much for giving us the opportunity to do the seminar on closing your claims. Hopefully this will provide some insight to everybody and we can give you some good information and getting your claims closed faster. And Diane, my moving bar is not working to advance.
Oh, can you try your mouse?
Oh, there we go. Okay. Thank you.
Sorry we're a little bit late. We were at the AWCP party last night and just rolled in, and I just wanted to let you know what sort of cocktails that attorneys drink. Ready? Subpoena coladas. You're welcome. Is this thing on? Is this thing on?
Oh, that was good. That was good, Jim.
Oh, I've got a whole bunch more. I can just roll them out.
All right, everybody. So we cover a lot of Northern California. Obviously, you can see Sacramento, Marysville, Chico, Redding, Stockton, Fresno, Salinas, Santa Rosa, Oakland, and San Francisco. And we have actually been doing some Southern California while the COVID is still in effect. So if you need help with down south, we're also ready to do that. All right, so let's get to closing your claim. Most problems that we notice with regard to getting a claim closed early and quickly is that we don't do the front end work. So the front end work is getting the ISO index so we can get your records as soon as possible. So it's incumbent upon the adjuster, if we can get that information as quickly as possible, then we can go ahead and start subpoenaing records and then start noticing red flags. So if we get red flags regarding, multiple prior claims or, just a significant history, other motor vehicle accidents are close in time, we can narrow that down and go ahead and request those records. So it's good to do that. And then getting the QME process initiated, go ahead, you get your PTP report, go ahead and object per Labor Code 4061, 4062, send applicant's attorney a notice, and then diary it for that 15 days. And on that 15 day, I know most of you guys want to clock out at, early, especially since we're all working from home. But if you can get on the DWC website and go ahead and request the panel right at 5 o'clock, we can get a jump and get those orthopedic QMEs instead of the chiropractics or the PM&R panels. So we want to get that started as soon as possible. You can always move out a QME exam, but get them on the records and get some pressure on applicant's attorney and the doctors to get the applicant moving towards the permanent stationary status. Another thing that I would like to see done is sending the actual PR4 form to the PTP. Sometimes we sit back and wait for them to declare them MMI, and sometimes if we send them the PR4 form and kind of put some pressure on the PTP, they'll start thinking, okay, that, you know, this one's kind of a pain in the ass. They want me to get, you know, the person MMI, so they'll work on that. Depositions. So depositions on every claim, I see it used to be the practice every time you got a claim, you would set the deposition of the applicant. And there are a couple of reasons why. One reason, if you set the deposition, we use that as the first opportunity if you couldn't get a hold of applicant's attorney, because sometimes they won't call you back, is to get the parties together and discuss settlement at that time. And I know it seems ridiculous, you should just be able to set an informal settlement conference or be able to, you know, easily make a phone call to applicant's attorneys, but typically they won't call you back. So you set a deposition, maybe you settle at the deposition. The things that we've been seeing is that, number one, unless there are huge red flags, we don't need to set the depositions. They're very expensive these days. They're $400 to $450 an hour for applicants' attorneys to attend the deposition. It's an automatic $450, $400 for the 1 hour prep. And then you have a couple hours of deposition time. And sometimes it gets you no further in the claim than you need to be. If we have a 20-year-old that happens to have carpal tunnel, it really doesn't make a whole lot of sense to set the deposition. Like I said, unless there's some other red flag, but we shouldn't be expending that money, and we try to weigh that when we're actually giving you guys advice on, you know, getting your claim, getting the discovery done, and what we need to do to get the claim closed. And Jim, I think you had some thoughts on the deposition.
Oh, yes, I do. Another thing we think about too is depending on the nature of the injury. Low back strain, diagnostics come back fairly normal. Do we want to depose somebody even if they're 60 years old to get, you know, 30% apportionment on an 8% case? Is that worth the $3,000 for the deposition? So we take those things into consideration. And also, you set the deposition, it's 2 months out. That's 2 more months that we're waiting that we could potentially settle the case. Also, when we do depositions, is an opportunity to settle cases. But what we're finding is, excuse me, attorneys in Southern California like to pick up cases, and they'll settle at the deposition, but then they want their deposition fees without actually doing the deposition. So they're doing a disservice to their client. But it's one way to get cases settled early is at the deposition, as we all know.
Right, and it's also unethical. We've seen some attorneys purposely wait for the deposition to be set, and they'll ask you for the $400 for the prep, and then they say, well, you know, why don't you float us 2 more hours because we would have taken the deposition, or, you know, it took us that long to discuss settlement with the applicant, so pay us more deposition fees. And we'd recommend not doing that. That's unethical to pay for the attorney for when they haven't actually conducted the deposition. And they shouldn't be able to hold that over your head for as far as settlements. Okay, so moving on, calling opposing counsel early. When I initially get the claim, the first thing I do is call opposing counsel and see if we can automatically do some CNR or if we can move towards stipulations depending on when you guys send us the case. And sometimes you just have to hound applicants' attorneys. Some of them communicate different ways. Some of them aren't just by phone, some are strictly email. Some of them even like to text. So, you know, knowing your opposing counsel and contacting them early and being diligent about following up with them, because most of them will just kind of put you on the back burner if you're not kind of you know, antagonizing them for settlement. And these informal conferences can be set by phone. I've had a lot of success in sending them in Zoom. It seems to be able to get their client to attend with Zoom, and then we can all talk about it. It works out well.
Also, regarding opposing counsel, we all know the applicants' attorneys that are easy to deal with, the ones that are difficult to deal with, but basically it's the same operation of moving forward is getting to settlement as quick as possible, getting to panel if necessary. Some attorneys we've seen will let the case develop. If you give them more time to let it develop, then they'll add body parts and, you know, diabetes and all these things get added. So even when the attorneys that are difficult, if you make it easy for them to get a P&S report, to get something to settle on, it really will help your case. And we, like I said, we know the attorneys that are easy, and we know the ones that like to, you know, drag it up and build up the case as much as they can.
Okay, so what we're going to be talking about in the next few minutes, we're going to be talking about pro per settlements, the documentation that you need, tips in preparing the settlement documents, adequacy of the actual settlement, lien resolution, and the differences between each WCAB. So pro per settlements, a lot of the times I get documents, they're signed by the applicant, sent to me from the client, and they say, hey, just do a walkthrough. And I notice when I review the medical records that when they've been going to the primary treating physician, they have an interpreter accompany them. And a lot of times when we send settlement documents, they'll have a family member interpret it, or that maybe they speak broken English, but enough to muddle by and assure you that the settlement is okay. I will let you know if there is a medical document saying that the applicant was accompanied by an interpreter. You will need a certified interpreter to sign off of it before submitting it to the WCAB. It will get kicked back if it does not have a certified interpreter on the settlement documents. In addition, it protects you so that the applicant doesn't come back 2 years down the line saying, hey, I thought I still had my open future medical care. I didn't understand. I didn't speak good English. They knew that. So it's very important to have a certified interpreter sign off on the documents. Another thing is knowing your venue and your judge, that some judges have likes and dislikes. We found that some of the ones in Sacramento are very much sticklers for each and every little detail on the settlement documents. So they really want you to complete the settlement documents. It was nice when we were doing walkthroughs by Zoom, so you could actually explain yourself if there are any questions. So, we're having to fall back unless you're going to do the walkthrough in person, which is, going to be more costly than submitting them online, and it seems to be working online very well. You want to know your judge's likes and dislikes. Okay, the proper walkthrough submission and documents for individual boards. Each board is a little bit different. Reading, has requirements where they want any pro per applicant to meet with the INA officer. The Sacramento board, not so much unless it's complicated. They won't make them meet with the INA officer. So you just, again, have to know which board and which documents to submit. Later in this presentation and attached, I've given you some documents that are basically samples of which boards like what things, and documents that you need for approval. ADJ assignment. If you have a pro per, a lot of times they have not filed an application. So that requires you to submit. You can use your settlement document to get an ADJ. You don't have to file an application and then do your settlement documents. You can go ahead and use any type of settlement document to get an ADJ assignment. But you have to do that first before you can either do a walkthrough or submission for approval. Is a settlement adequate? I think, Jim, you wanted to talk about that?
Yes. Adequacy with pro pers is obviously different than it is with somebody who's represented, because they have an attorney that can look over the file. So when it goes to the judge, depending on the attorney, will look at it and say, okay, it's fine. But with pro pers, you really have to put yourself in the shoes of a judge when you're settling. And I know we're all here to mitigate and save money for our clients. I mean, that's why we're all here. But when it comes to a pro per applicant, you have to look at it in the light of the eyes of a judge. Like, if the judge is looking at that, what are they going to think? I mean, you've got a guy who's got a surgical back, and it's definitely surgical, but they only give him a DRE 2, and it rates out to 20%, and you want to settle it for $30,000 when it should be $80,000. The judge is going to look at it, and once you do that, the judges, they remember who tries to get settlements through that aren't above board. And then the next, if that happens a couple of times, then they start really, really looking at the file, looking at the medical reports. And sometimes you get in a position where, well, we got low back, but then he was also complaining about his knees, and the doctor didn't address it. So why don't we send him back to the doctor or go to an IME, and now your case blows up? So it's just a good practice to make sure that your settlement's adequate, it's fair, it makes sense. Something that you would give to a represented applicant, do the same for the pro per to get it through. It's, saving a couple $1,000s here and there doesn't really pay off when you get kicked back, and now you have to either get counsel to help you, or you have to, redo the paperwork and change your settlement value. So just keep that in mind for adequacy on pro pers. It needs to be fair, and it needs to be correct.
And are there any liens? Obviously, the quickest way to do that is to go to EAMS, put in your ADJ, do a case search, and they have a lien search. So you can figure out whether or not there are any liens filed with the board. Typically, it's only EDD that you see. What I've been seeing lately is some short-term disability or long-term disability liens, and they don't often file with the board. And they usually just send you a notice that, hey, we provided short-term disability, long-term disability benefits. So even though there isn't a lien in Eames, you're still responsible for resolving those benefits. Just as child support does sometimes file liens. But I want to know, a lot of people don't know that child support liens, you're only obligated to pay from the date of injury forward. So if the applicant prior to the date of injury has 3 years of child support in arrears, you are not responsible for resolving that part of the child support lien. It's only from the date of injury forward, and it's only against indemnity benefits, not permanent disability. So it's only against temporary disability that they receive, and they usually let you know, they're garnished. They want you to withhold up to 25%. So you need to withhold that 25% and also get them to sign off on the settlement documents when you submit that for approval, so that you know that that's completely resolved.
And also, remember, lien claimants, we all know they don't know all the rules. They don't know the law. They will try to baffle you with, oh, you owed all this in interest, and they didn't file it timely, or they didn't send you the bill properly. Even with the child support services, you would think that's all they do, so they should know how to deal with liens. And we have a case where they actually were trying to go after the permanent disability and filed a petition with the board, and the judge said no and suspended it, and so it's moot. But you'd think they know that they don't get PD, and they've also have had another case where they think they should get 50% of their temporary disability, and I had to provide the case law saying no, you get up to 25%, but it's a judge's order. So just keep that in mind with liens, that the people you're dealing with don't always know all the rules and all the laws. And hey, Hillary, did you hear about the monkeys who shared an Amazon account?
No.
They were primates.
Oh.
Is this thing on? Is this thing on? Check one, check, mic check. Okay.
All right. So anyway, talking about the liens, EDD is very difficult to reach, so we all know, but they do have email addresses. So if you call, sometimes you can get a direct email address for the EDD representatives, which is helpful, and sometimes they will respond. If you need help with that, you can email Jim and myself, and we can see if we can find you an EDD representative if you need to resolve their lien. All right, documents that you need. So notices to the applicant of the QME options and waiver. So a lot of times we get pro-pers that don't want to go through the QME process, or we've convinced them, that, hey, they want to settle, they don't want to go through the QME process, whatever it is, whatever the reason is. We're finding that it is not adequate to just put that in the settlement documents. I'm not saying that it doesn't work, for some judges, but it seems to be getting rejected, that they want an absolute separate waiver saying you've been notified of your rights to a QME and you've elected not to use the QME process. I did provide a sample at some sample language. It's not, exclusive. You can obviously add to it or subtract from it, but it does give you basically a template that you can use to get the applicant to sign off on the QME waiver and make sure that they understand those rights. It's very important. They need to be sent the notice in writing if you're going to do that. Notices to applicant of options for settlement, the DEU form 110. If you go to the DWC website, there is a form that you can use, and most claims handling have some type of, this is your stipulation options, this is a compromise and release, but just advising the applicant of their options for settlement is nice if you can provide that also to the judge when they're pro-per. So pro-per walkthrough submission documents for individual boards. Again, I will give you a couple different samples at the end of this that you can look, that basically tells you each type of document, and they're all fairly similar of what documents you need. And actually the DWC also has kind of a checklist form. It's a 2-page, basically itemized checklist of what they're looking for in settlement documents for approval, which I think is real handy.
Also, going back to the waiver, one quick sec, but we've had cases where we've actually wrote language in the CNR that said the applicant has been advised of all his rights regarding going to a panel. He's been advised as a 5-year statute of limitation, writing everything that we need to tell them the judge wants us to tell them, which is weird. We're advocating for the applicant, but it gets the case settled. And we've written it in the cover letter to the WCAB. We've written it in the CNR, and we've still had the judge come back and say they want the waiver. And it's written twice, once in the settlement document, once in the cover letter. And then we end up taking the same exact language that we put in the CNR and making a waiver to send it to them. They sign it, we send it to the judge, and then he's like, okay, that's good. So it's form over substance, but they want those things done. It seems like recently they want it a lot more. We've been doing it for years where we just include it in the settlement document, but recently we're seeing a trend of the judges actually want something signed.
Okay. And that waiver does not need to be witnessed or notarized. It's just signing the document that they've been advised, unless there's an interpreter necessary, and then you might want to, then you'll have to have an interpreter line signed off on that. All right, so more documentation. ADJ assignment of no application takes time when you're walking it through. Settlement documents can be used to activate the case. We discussed that earlier. But please note that it does, depending on the board, if you submit settlement documents with a request for ADJ assignment and then approval, we've seen it come back in 2 days. We've seen it come back in a month. So there's just no rhyme or reason why the judges take longer than they do. They have what they will tell you up to 90 days to approve your settlement. Hopefully it doesn't take that long. It doesn't seem to be taking that long. All liens addressed or settlements filed with the board. When you're settling your claim, it's important that you make sure that the liens are addressed in the lien paragraph, saying if it's EDD, have the EDD representative sign off on it, that it's been full and final satisfaction for all dates of benefits provided, and then have them put their, their address and the tax ID information. If it's any other liens outside of EDD that you have settlement, say it's the STD, long-term disability or short-term disability or child support, you can file a separate document. It doesn't have to be a stipulation order. It can just be a signed agreement between the parties that you're agreeing to pay and resolve all interest, penalties, and all benefits provided to date for a certain amount. I would recommend that you never, ever put hold harmless language, no matter how much applicants, attorneys, or want that in there. There is absolutely no benefit for us putting a hold harmless. That basically means that if the applicant was supposed to pay child support and didn't, and it was supposed to come out of the settlement, then you are put in the shoes of the applicant. So you are then liable for that lien and resolution when you shouldn't be. So I would highly recommend not putting hold harmless language. Return to work offers to the applicant a provision of the supplemental job displacement voucher. So a lot of the times the applicants receive temporary disability or modified work or salary continuation. So we need to make sure that that's clear in the documents too. If the applicant had a return to work offer and accepted it, whether it's full-time or permanent modified position, if you want to include that with the settlement documents, or note in the settlement documents, the applicant returned back to work for the employer. You can also put that in a cover letter, which is helpful for the judge. If you're doing a CNR and they still remain at work there, it gives them an idea of why they're not being provided the supplemental job displacement voucher. So you want to note that in the settlement documents or the cover letter to the judge, which we'll talk about a little bit later. Okay, so tips for preparation. A lot of times I get stipulations or compromise and release documents and the other box is completely blank, or in paragraph 9 where you initial all the issues. I like to initial all except for the supplemental job displacement voucher box at the bottom. You can't initial that because we can't settle it. But all the other boxes I initial, and if a judge wants to call me and say, hey, you don't need to resolve those, that's fine. Some of them do have issues with that, not so much in Northern California. But where it says permanent disability, I put in on that paragraph 9, when it says permanent disability, Dr. Shaw rates at 29%, permanent disability, so that it's included in there. And then the other, I use that to put in resolves all out-of-pocket expenses, mileage reimbursements, labor code 5710 fees. You can put that in that other, that it's resolving all those issues. So it's clear in the settlement. And then in the other paragraphs in the lien, I gave samples, like I said, attached to this, where it says how, how defendant's going to resolve the liens, pay, adjust, or litigate all through the order approving compromise and release, or date of the order approving, no known liens filed to date. And that's helpful for the judge, that you've actually checked that box and gone over and made sure that there aren't any liens. If there is a lien, then you put it in that paragraph resolving it. So Also, keep a copy of the settlement documents. I have a lot of times where people send the applicant the original document. They'll print it out, send it to the applicant, it won't keep a copy. And then the applicants lose it, and then you're drafting all the settlement documents again. So make sure you keep a copy for your records as well as theirs. The separator sheets, requests for walkthrough, a walkthrough cover letter, and assignment ADJ. So our practice now with every settlement that we're submitting to the judge, obviously you submit the medical report that you're relying upon. You don't have to submit the entire medical file, but if you have a PR4 report or a QME report, obviously file those with your settlement documents. You need to do a request for walkthrough when you submit those on the separator sheets if you're doing a walkthrough, if you're not doing it in person. But you need to advise the judge when you're submitting them names that you want this approved. And you want to do a comprehensive cover letter. Jim, do you want to describe what you put in the cover letter?
Yeah, what I basically do is I do 5 things. I let the judge know what exactly we're looking for, which is adequacy, approval, and for the judge to review for adequacy. If it's pro per, we need an ADJ. That'll be the second thing that I'll put in there. So the judge reads it. That's the first thing he sees. Then I'll put in mechanism of injury, what body parts, the rating, and I'll give the string rating and how much permanent disability is, what the doctor says for future medical treatment, what does it include, and if it's not surgical, I make sure to say Dr. Shaw says the applicant is non-surgical, so that it's in the judge's mind that, okay, it's conservative treatment. And then lastly, I'll put in that the applicant's been advised of all his rights. So it only needs to be a page, page and a half. Doesn't need to be 3 or 4 pages. Just give them the hot points that they're going to look for when looking for adequacy for settlement. Also, I wanted to go back a little bit on filling out your documents completely. When you have broken periods, temporary disability, and wage loss, that doesn't really fit in very well in the spots. So what I do, and Hilary does, is we'll put it down in like the lien section and thoroughly explain, TD from this date to this date, this much weekly for a total of this much wage loss paid between these periods. So when a judge looks at it, they have everything they need, so they don't have to suspend it and set it for a hearing, because we're not there. If we were actually at the board with our walkthroughs, it'd be a lot easier. But since you're trying to present it to a judge to give them everything they need, you need to give them everything they need to make it easier on you, and that'll also get you faster settlements. And I think that when you do that over and over again, the judges they'll recognize the name and they'll give you more deference on smaller issues. So we that's a practice we like to do. Also, with the Southern California attorneys, something else that we're seeing is that when we send them a signed settlement document, they'll send it back signed and say, go ahead and walk it through. Make sure to review the entire document. We've had a handful of attorneys change things and then not mention anything, not tell us anything, or email and go, hey, Jim, you know what, I added something in this section, or I crossed something out, or the worst one is when they white it out. So you're looking at it and you're like, I usually will add something in there like the applicant stipulates that all payments are to be sent on page 1 of the settlement document. And if they white it out and you're looking at it, so just make sure it's the exact same document. Like Hilary said, keep a copy. So when applicant's attorney sends it back, you can compare it, because we've had it happen before. So that's a really good practice.
Right. Okay, so Jim kind of touched on this, the wage statement calculation of average weekly wage, TD, permanent disability rates, and explanation of the wage loss or salary continuation. Again, it's very important. So if you have stipulations or and you submit those to a judge, if you do not provide, if the applicant is less than max, it can happen that a judge has discretion to order that the applicant be paid max temporary disability if you do not indicate why they are less than max. So always include the wage statement if the applicant is less than maximum, and again, outline very clearly in the stipulations as well as a compromise and release why they got salary continuation, what periods, and their wage loss and what they received. And it's difficult, especially in the stipulations, because there are 2 paragraphs where it gives you the first opportunity to put the first period and then a second period, but sometimes they have 3, 4, 5 periods of different calculations, and it's not just temporary disability, it will be salary continuation. So where do you put that? Put that down in the other explanation paragraph in the stipulations, and really line it out what they received. It's very important to do that. Medicare set-aside language, structure, self-administered, and confirmation of with the vendor that they're eligible or not. So the MSA language, obviously, that everybody has different addendums saying it's self-administered, it's administered, it's structured, it's not structured. You really want to outline that also in the settlement documents or attach it as an addendum and indicate clearly whether or not it's self-administered or not. Even if you don't have addendums to put in there, but you're indicating the applicant is not Medicare eligible, but we've taken into Medicare's interest into consideration, that's good to put in there if they're close. I mean, they have to be within 30 months, but you want to make sure that you do discuss that if it's around that time for older individuals who are settling their claims. We talked about this a little bit, running EAMS for liens. Like I said, you can go in there and run a search through the DWC website, and then make sure you're resolving EDD and child support and putting that in the documents. Also, I see a lot of time, because we use EAMS, a lot of our computer programs pull over. If you put in the ADJ into your program, it'll automatically import everything from EAMS. Well, EAMS is notoriously incorrect. The TPA is incorrect. They'll say TPA from, Corval Chino or Corval Sacramento, and it's, Corval Fresno. So you need to check and make sure that the correct TPA is in there. Also the correct name of the insurance company. A lot of times they will list, incorrect employers will say they're the insurance company, or the employer will not be correct. It'll be somebody who worked for this company who's a payroll employment organization, but were venued in working at this certain employer, site-specific employer. So you need to make sure that the correct name of the employer and the TPA and the UAN name is in there. They're really looking at that on the settlement documents when you're turning them into the board to make sure that you have the correct UAN name and number on the documents. We used to be able to leave it blank. You can't do that anymore. Okay, so tips for preparation. Jim, do you want to talk about the PD ratings?
Yes.
Yeah, Jim.
Again, like I talked about earlier, is I always include the rating strings in all settlement documents so that there's no question. And the reason why I started doing that years ago was because I would get a case where it was settled in 2005 and they'd have a new case on low back, and we get the stipulations and it wouldn't tell me, how did they get to this number? And a lot of times it was a compromise of numbers, so it was harder to get the apportionment and to go to a doctor and say, hey, listen, this is what the first doctor said. So I always include it. So there's no question down the road if the settlement document gets in somebody else's hands and they want to see what the rating was, it's the string rating's there, everybody signed it, everyone's agreeing to it. And also, like I said, helps the judge out so that it's easy for the judge to say $16,000 in PD and adding, $14,000 for future medical treatment and a $30,000 settlement. So that is helpful. Also, the doctor's name and the date of the report, so that somebody can access it and the judge can also understand exactly what you're relying on. Hey, Hilary, I was going to ask you, do you know what country has the fastest growing population?
Nope.
Ireland. Every day it's doubling. Is this thing on? Check, mic check.
Oh God. Okay.
You're welcome.
And I married him. Okay.
Millions of men to choose from.
All right, so special information such as a basis for denial. So if you're denying certain body parts, especially in stipulations, sometimes you'll have them claim 3, 4 body parts, but you only come down to 2 based upon the doctor's opinion. You want to note that in the stipulations that, these are the specific body parts. It actually gives you a paragraph to say what body parts. You can use that paragraph to say, we accepted the shoulder and the right, or the left shoulder, right knee. The low back is denied based upon the medical report of Dr. So-and-so. So that's clear that, hey, we know that body part's out there, but it was denied. So when it comes to a petition to reopen or looking back at the claim, we can say, okay, those were addressed and denied. And again, it makes it easier for a judge. And another thing about the PD ratings, there is case law that says if, say you do a compromise and release and the parties agreed to settle for $25,000, but they assumed that they were basing that on a 5% rating for the low back, and that's how they arrived at their number. If you don't put in that rating in your compromise and release, when you go to have another claim down the line and you want apportionment, the percentage of permanent disability is not automatic for the judge unless it is documented in the compromise release or the stipulation. So that's why you want to add those permanent disability ratings in there. A lot of applicants attorneys don't want you to do that for that very purpose. They'll say, well, we don't know what the rating was, you know, when you go to get apportionment or go to litigate it. So you want to make sure it's in there. And a lot of times, if it's an older CNR, you can no longer find that QME report, or it's not in the board file. So you're out of luck as far as apportionment goes. So also the justification for why you are providing the supplemental job displacement voucher or are not. Again, like I said, if the applicant is returned to work, it's good to note that in the settlement documents, you know, the date that they returned to work, and that's why you're not providing the supplemental job displacement voucher at this time, especially on stipulations. You can say he returned to work so that you're not obligated to produce that. Obviously, we know that you have to send out the notice of offer of return to work, modified or permanent, for the applicant within 60 days of the QME permanent stationary report. Otherwise, if it's not in writing, you have to provide the supplemental job displacement voucher anyway. So it's kind of that is a formality that you have to comply with.
And also with the voucher, one thing that works really well with pro-PERS, if they're due the voucher, they're due the voucher. After 2013, it's black and white. If it's owed, it's owed. And if you're helpful, you know, let's say we had a case where it was $25,000 settlement, and he was due the voucher, and he's a construction worker. He's never going to go do anything but construction work, so you'd have to worry about the $6,000 of benefits. But I helped him out. I filled out the $5,000 state form. Am I back on? Sorry.
Okay, so adequacy. Okay. Oh, I think Jim was muted for a period. So adequacy, but he was finishing off on the supplemental job displacement voucher and just saying, helping the applicant fill out the supplemental voucher to get the $5,000 from the state. He was able to actually close the claim with the applicant because it gave him that additional $5,000. So that may be something you can kind of throw in their face. If you don't quite have enough settlement authority, you can throw that out there. Hey, you can get free $5,000 from the state, easy to get. All right, so adequacy, signed documents, witnessed or notarized, interpreter certified. Obviously right now the COVID emergency guidelines have not been yet lifted, so you do not have to have the CNR or the stipulations witnessed or notarized at this point. That I assume that will be changing fairly soon, maybe after the beginning of the year. They may go back to having it witnessed. I honestly don't think the witnessing is miraculous in any sense. You can never tell who witnessed it. It's not like you could find that person again anyway. Notarization, obviously, you can document and find the, you know, notary, but the witnesses is kind of an old, antiquated formality. The certified interpreter, again, like I said, if you have somebody Spanish speaking, it needs to be a certified interpreter, and their certification number needs to be on the settlement documents. A lot of times you can request interpreters to do this fairly quickly. Just make sure that they're not overcharging you for reviewing and signing the documents. It should be no more than an hour. It literally probably takes them 15 minutes, but they typically charge 1 hour a time. Ratings by the DEU or the adjuster. When we get the settlement documents, we need to make sure that the ratings are correct. A lot of times I see incorrect, you know, not purposeful, but there will be an incorrect occupational variant, or even the ratings by the DEU. I mean, they're not, you know, the authority on ratings. They make mistakes also. So you need to make sure that you're challenging a DEU rating if you receive it and it's incorrect. A lot of times they take a lot of liberty on interpreting medical reports without, you know, any justification, and they'll put in a rating there that's like they're assuming this is what is required per their job, but it's not. So make sure that you're double checking those DEU ratings and that they're accurate. Make sure that they're using the correct occupational variant, and that the string ratings are the correct body parts, and that they're not using something else or adding to it that you need to challenge it, because you have to file a petition to challenge the DEU rating. I think it's within it's been a while, 10 or 15 days. I'd have to check on that. CNR, Jim talked about this, basis in the amount of settlement. Obviously, you know, you can go on the lower end with pro per applicants, but don't do it so that it's so ridiculous that the judge will find that you're not credible and not reliable, and that when you submit settlement documents in the future, they're just going to suspend it every time. They do kind of keep a list of people who do that, and they all know who those people are. So make sure you're doing a fair analysis and providing for future medical care for the applicants. MSA required language and addendums. We talked about that, where, you know, we need to make sure that we're covering Medicare's interests if they're, you know, able to apply. We do have a lot of different companies that have different thoughts on the MSA. Obviously, getting CMS approval is not required. It's strongly encouraged, and a lot of the insurance companies will require their adjusters to get MS or CMS approval, just so that they're not hit with treble damages, that they've submitted, you know, a correct projection of future medical care for this applicant before they apply. Having said that, I don't see a lot of CMS coming back after people. It has happened, but I don't see it, you know, as a regular basis. The MSAs, though, I have to say with CMS have been coming back very quickly. So don't be afraid to get CMS approval. They honestly have been coming back, and sometimes they're 2 weeks, you know, 3 weeks, 4 weeks max, but they are very quick at this point. Limiting language. So this is something I see a lot of adjusters will submit like stipulations, and they put in that other paragraph that they limit the medical to what the last PTP PR4 report said. You know, I expect conservative care, you know, may need this. Like it's like you're able to limit the applicant's future medical care. The whole point of a stipulation is that you have a future medical care award. That's the whole purpose of that document, is to have open future medical care, and it's up to a judge to decide. It has to go through UR process. So putting that limiting language in there it has no effect, basically. So I just wouldn't include that at all in these settlement documents for stipulations.
Also, regarding the MSAs and submission, I've had a judge, I think it was in Oakland, who we had an indemnified Medicare set-aside analysis, which means that they're basically going to protect everybody that's signing the document, the applicant's attorney, defense counsel, and which is great, because then you don't have to submit it to CMS. I think it was Oakland, but we tried to submit a CNR and it was kicked back, and the judge, and I talked to the judge via email and said, hey, it's indemnified, everybody's protected. She said, it's our policy here to, has to be submitted and approved by CMS. So things are always changing, and settlements, you know, like we talked about earlier about the notice of PQME waiver. We were putting it just in the document for years, and now all of a sudden it seems like different judges or things change. So always keep a lookout for those subtle changes to help you get your settlements done quicker. And hey, Hilary, you know, what do you call someone who immigrated to Sweden?
I don't know, and I'm Swedish.
Artificial sweetener.
Oh,
You are welcome.
I just let you know he did not get these approved by me before he said he was going to do these.
Oh, I think I'm still from last night. I'm just, you know, sorry.
Okay.
It was a good time.
All right, and so we've already kind of talked about liens and EAMS. Again, like I said, I would just reiterate making sure that you're including all dates, so the EDD doesn't come back and say, oh, you only settled this period, you didn't settle this later period. Especially if you have co-defendants, make sure that you're resolving all dates at the time of settlement. Okay, so penalties and interest. So if we make that oopsies and don't pay the CNR timely, just know that the SIP that you pay on temporary disability is automatic, but it is not automatic on permanent disability payments with lump sum CNR award. So it's only on periodic indemnity, meaning temporary disability. It's not automatic on the CNR. That's not to say that there isn't a penalty that you would pay under 5813, where they could get 10 to 25% based upon the judge's discretion, based upon the lateness of your payment, but it is not automatic that you put 10%. If you agree to put 10%, obviously that goes a long way. Say you're a week late in paying it, you should have paid it, you know it, and you put 10%. it's not likely that a judge is going to come back and award 25%. So unreasonable delay. So a lot of people think that, oh, you know, the CNR was late one day, therefore it's automatic. It is honestly up to the judge's discretion, and I've seen different cases go different ways. I've seen where we had, you know, a judge, the envelope, the adjuster inserted the payment on the day before it was supposed to go out, and actually the check was inputted through a system, a bank back east, and the check actually didn't issue until 5:02 the following day, which is technically after business hours, and he awarded the penalty. Obviously, we reconned that, and they didn't agree that was an unreasonable delay. But just know that there are some judges that will be that hard-nosed, saying, hey, it didn't go out, you know, before the 30th day. It went out at 5:02, which is after business hours, therefore it's late. So it can happen. They can assert 5814 penalties, but I would definitely argue, depending on the circumstances, there's also business reasons why the check, you know, may have been delayed. You know, maybe the adjuster was out on COVID, they didn't have anybody to cover. I mean, there are certainly things that you could testify or submit to a judge to say, hey, it was unreasonable or business practice, you know what I mean? It's definitely arguable. The other thing is a fair balance. Say you have a CNR that's $350,000 and you were late one day. So, I mean, you're talking a hefty penalty on $350,000 being 10% or up to 25%. So the judges also, under that Gallimore case, do have a fair balance between what's right for the employee and the prompt payment of compensation and the imposition or harsh or unreasonable penalties based upon the delay. So they will take that into consideration. It's not automatic, and I think some people just automatically pay without arguing that sometimes, but an attorney could help you out and maybe argue that for you.
Also, with the language in the CNR, we both always put in, it's up 30 days upon defendant's receipt. So if applicant's attorney walks it through on the 1st, but then you don't get the document till the 4th because he walked it through on a Friday and you get it on a Monday, that's when your clock starts. So always make sure it says upon defendant's receipt, 30 days upon defendant's receipt.
Yeah, defendant's receipt of the order approving.
Right, not just, on the order approving, exactly.
Yeah. So again, this is another case that you can use. It's an old case, but it basically, you know, I think people forget when they, you know, they make that mistake. It's, you know, it's horrible. You have to go to your supervisor and tell them, hey, I, you know, forgot to pay it or it didn't get paid. But there's a lot of case law out there, and there's even newer case law that talks about, you know, the reasonableness and the substantiality of why the payment was late. And, you know, there can be a good business faith reason why it was late. So we come to each, WCAB is different. We're getting towards the end here. Know your judges. There's certain judges, if you're going to do walkthrough dates, talk to your attorney about that. There's some judges that we know are easier to get documents approved than others. That's one of the benefits of having an attorney, knowing the judges. I have a long-standing rapport with a lot of judges because I've been doing this for a long time. I know which ones are easy. I know which ones are bad. And I know which ones I can get approved with basically limited or no questions at all. Know your different submission and walkthrough procedures. Again, I have a lot of lists at the end here that you can use to make sure that you have every document that you need before submitting. EDD representatives, they've been changing quite frequently lately, and they're very difficult. All EDD representatives have marching orders right now to get interest on all the late payments that you have not made. So, you know, be aware that we used to be able to negotiate that out. It's very difficult to negotiate no interest at this point in time. You may be able to get some of it off. Some of them are a little more flexible than others if you're willing to pay, but know that a lot of them have marching orders to get the interest that is due. And so when you have a pro per, I know Reading has, like I said, an automatic where they send everything through the INA officer. The INA officer has a checklist, which you'll see attached to here, that they go through and make sure that everything is complete in the settlement documents. If it's not, then it will be sent to the judge, and the judge will issue an order suspending. So you want to make sure that, you know, if you can talk to the applicant in advance to talk to the INA officer before it even gets there, that's better, or even set up a meeting with the INA officer with yourself and the pro per so that you can make sure you guys are all on the same page and that the documents are well signed off. And then the INA officer will be aware of that. Sacramento is not so much involved with the INA officer. Southern California has a lot of INA officer participation. And just be prepared. The rules change. We may tell you, hey, you need this one day, and a judge will tell you something different. We all hop on to the judges online every day at our appearances. Some of them want you to email the minutes of hearing saying we want it off calendar. Some of them will sanction you and threaten all sorts of horrible things to you if you email a judge prior to them giving you permission. So you have to know your judges. They're all different. They claim they all do the same thing, but they don't. So that's one of the things. So again, these are all the offices that we cover in California. We're happy to assist you with any of your issues or claims, or if you just have a question, if you want, settlement document question, please email us, let us know, and we can help you answer question. Again, these are the samples that I've given you, some typical language. This is an old stipulated award. Some of you guys may have those old crusty claims that haven't stipulated that are still subject to the 15% increase or decrease per Labor Code 4658. They didn't give you a place to put that in the documents, so this is how I would put it in the documents. I would make a little asterisk next to the total sum, and then I would put that in there so that you could indicate whether it was including that amount or not including that amount. And then again, some suggested language for stipulation and award. Here's the other paragraph that I was talking about where you need to put in the ratings, no TD is owed to the applicant, just some suggested language, resolving penalties and interest, if you'd like to put that in there. Here's a stipulation award, if you're agreeing to resolve a lien, you can submit a stipulation award in order for approval, or you can just do a document where you guys agree and both sign off on it. CNR, this is exaggerated, but again, some suggested language you might want to consider when resolving your CNR. It's always difficult for the permit disability advances. I put C paragraph 8 below where you can indicate that it's all permit disability advances through the order approving compromise and release, because sometimes it takes a while to get the applicant to sign off and return. You've advanced a couple more PDAs than what was sent to him on the original document. So always note that it includes all permit disability through the order approving. And this is where I was talking about in paragraph other, where you're resolving medical mileage and out-of-pocket expenses. And then you can see under comments for permit disability, or you can just go ahead and put your permit disability ratings in there. And these are the checklists for pro-pers. There's a couple different samples. This one happens to be from the Reading board. This one also was from the Reading board, but it was from Judge Salprizio. This is the one she liked, and I can't remember the other one that retired. Judge Sala used to require this one before, and that's what they sent to the INA officer. Here's another just generic walkthrough sheet that we have, checklists. Here's a sample, the affidavit of the waiver of QME process that you can use. And I believe that's it.
Well, that's not it.
Alexis.
We have to go a little bit longer because we started late, so we're just gonna keep everybody.
No.
I know, I'm just kidding. But hey, Hill, I wanted to know, do you know why Shakespeare's wife walked out on him?
Why?
Alexis, stop. Sorry. She was
No, I
giving
don't
you.
know why Shakespeare.
Did you give us the end of the joke, Jim? I'm sorry.
Oh, she was sick of all the dramas.
Oh, very good, very good. Well, I have one for you, Jim.
Yes.
What do you wash your hands with during the holidays?
I don't know.
Sanitizers. Sanitizers.
Sanitizers.
Were you at the party too last night, Diane?
Yeah, something like that. And then another one is why do you never see Santa Claus in the hospital?
Don't know.
Because he has private elf care.
Oh, God.
All right.
Too.
We do have a question. We do have a question for you.
Okay.
The question is, this person called EDD and she ended up in voicemail jail. She never ended up speaking to anybody. Do you have a good phone number where she can reach a live person?
It depends on the board that you're calling. So if she wants to email me directly, I can give you some inside either emails or some phone numbers of some EDD reps. A couple of them changed recently, but yes, it is very difficult to get a hold of EDD. You're right.
Well, if she puts in real quickly which board it is, I'll tell you. But Jim, I do want to let you know that somebody actually says, thank you both very much for the great information. Thanks for the laughs, Jim. So, hey, somebody really appreciated that.
Well,
All right. I don't see that she mentions what board. She hasn't typed that in, but maybe she can email you. Can you give an email address real quick? And that way.
Yeah, it's HIL@mcworkcomp.com. So 1L, HIL@mcworkcomp.com. And I'll do my best to help you out either with an email or a phone number if I can get it.
All right. Well, this was the 8th of the 12 days of CEUs for Christmas. We thank you very much for participating. We have 4 more coming on board today. Later on today, we have one on audiology. Boy, that was a tough one to say. Jim, I must have been at the same party you were at.
I wish you all a happy and safe holiday. Thank you all for joining. Really appreciate it. And if you need any information, like I said, you can likewise email me at hill@mcworkcomp.com or jim@mcworkcomp.com with any questions or dad jokes.
Till 1:30. We'll see you guys later. Bye-bye now.
Good
Thank you.
times.
Bye-bye.
Good times.